Hi, everyone. You got Charlie Albacetti here from Vicente Cedarburg, and we're going to be doing a webinar presentation today on private financings and cannabis. So I'm just going to say a few introductory words here and give everyone a chance to join, and then, in a few minutes we'll kick into the sort of the meat and potatoes of the presentation. So yeah, like I said before, this is a discussion about private financings and cannabis. So the focus is really on private offerings and not so much on public financings, public offerings, though a lot of the issues that we'll discuss here that are important for private cannabis companies raising money also apply for public companies. For example, we'll talk about some of the unique considerations you need to think about for debt financings. Obviously, if you follow the cannabis industry, you've seen a lot of sort of large public cannabis companies have raised debt financing. So these issues would apply to them just like they would to a private company. So here are the presenters. Myself, I'm based in Boston, though I spent the last 5 years in Denver, and before that I was in New York. Sahar, who's based in LA, and Elliot, who's based in New York. All members of our corporate department, our corporate team here at VS, and Sahar also does a considerable amount of work in the licensing and regulatory compliance worlds. All right, so to jump right in here, we're going to talk about sort of the challenges, and I don't think I need to tell most of the people in this presentation that things have gotten harder in 2020 than they were in 2019, and certainly more so than in 2017 and 2018. For a long period of time, it was quite easy for cannabis companies to raise money. I mean, there were challenges like, any company would face with raising money and the issue around illegality, but there was just a tremendous amount of investor excitement about the space. And I think that sort of paved over some of the hurdles that people run into when they're raising capital. But we're now in a pretty challenging environment to raise money. That said, cannabis sales are holding up, maybe in spite of COVID or maybe due to COVID, everyone just being stuck at home and they need some relief from the stress of what's going on in the country right now. But if you look at the companies that produce reports on sales, you'll see that you're seeing record sales year over year, even in places like Colorado that have fairly mature markets. So the underlying industry is doing well. However, the financing market is challenging, right? So obviously, public stock is easier to track. And you can look at the numbers, and depending on which analyst you look at and sort of where you cut it off, you come up with different numbers for the decline from peak to bottom. And there are all some indications that perhaps we've hit bottom and we're trending up now. We don't need to get into that. We're certainly not stock analyst experts, but I think we can all agree the stocks have gone down considerably, and the pressure from these public companies has created sort of, you see the same thing on the private side. You're seeing a lot of pressure on valuations, and it's just become harder to raise money. That said, people are still out there raising money. We're working with clients who are closing capital every week. It's doable, but and of course, this would apply even in a good market, but you want to set yourself up for success. You want to do everything you can to make sure you don't have any unforced errors in the fundraising process, and you're setting yourself up to ensure that you have the best chance you have at success in the tough conditions. And sort of the big takeaway here, I would say, is raising money for a cannabis company is like raising money for any company. A lot of the challenges remain. If you take one thing away from this presentation, it's think about the regulatory issues you're going to face when you're raising money, whether it be simply the fact that it remains federally illegal, or the fact that maybe you're going to need approval from multiple state regulators to close your round. Think about that up front, game plan it, write it down, prepare it for investors, and when they ask you, you've got your answer ready. You've thought about the issues in advance, and you've mitigated the risk as best you can. So without further ado, we'll get into some specifics here. So setting up a company for success. So again, this is one of these issues that applies across the board for any company raising money. You want to make sure you're set up in a way that's going to maximize your chances to raise capital. So, we don't have to get too much into the basics here, but part of it is forming the right entity. Most people that raise money are going to be LLCs or corporations. Traditionally, most people are corporations, so you do see a lot of people raising money into LLCs these days. We can sort of dive into this on another day, but there can be some unique considerations with 280E if you're a plant-touching entity that may make being an LLC more challenging from a fundraising perspective. But again, you simply want to make sure that your company is structured in a way that it doesn't create an additional hurdle for you from a financing perspective. So you want the investors to be focused on your value add, your business plan. You don't want them thinking, I can't believe these guys created a limited liability partnership for their startup. That's very strange, right? So you want to stick with it. That's sort of my general takeaway when it comes to formation is you want the company's investors, in particular the investors' lawyers, to say, yes, this is set up in a way that seems to make sense to us. They've done it by the book. Jurisdiction, you're still seeing, and we've sort of written a couple articles about this, but most of the companies that are raising money remain Delaware entities. There's some nuance here with the cannabis company that we can sort of discuss if it's helpful to the group, but you are still seeing Delaware as sort of the jurisdiction of choice for most of these companies. And I add foreign qualifications here because you always want to make sure if you're doing business in the state, you're qualified there. So don't form a Delaware entity and then neglect to qualify yourself to do business in the state where you have operations. And then, this is just the basics of being investment ready. Things like making sure that all your employees have signed proprietary invention assignment and agreements. So they've agreed to contribute any IP they develop for the company to the company, and that they're bound by a confidentiality provision. You'll see that documents like that are typically, you're required to deliver representations to that effect as part of a financing. So you want to make sure that you're going to be able to do that without cleanup. So if that's something you haven't done already, take care of it in advance of raising a financing round. Same thing goes in terms of making sure your books and records, your corporate governance is tidy, cap table is clean, you've documented all your ownership, you've got SOPs and good business practices. And if you're wondering to yourself, am I, quote, investment ready right now? I always say, I think the best way to do this is to talk to your lawyer, get a due diligence request list that they would typically send someone that they were potentially buying or investing in. Look through that list and make sure you've got great answers to all those questions. And then, in advance of a raise, you want to make sure you've got all those documents gathered already, uploaded into, whatever platform provider you want to use for diligence. But, so you're not caught off guard when an investor asks you a question about one of these items. All right, so just talking about the different stages of financings. Okay, you formed your company, you're set up right. That's step one. Then what people call the seed stage, and this is sort of early round financing, friends and family. You see a lot of safe notes at this stage, convertible notes, sort of simple common stock investments. Then you get to the early stage investments, the Series A investments, where you're bringing in kind of institutional investors for the first time, though, as we'll discuss later, you see less institutional investment in the plant touching side in this industry. And then finally, your later stage investments, B, C, D. And obviously we won't have time to get into the nuances of these later stage investments, but what we're going to talk about today applies to pretty much all of the stages of financings here. Forms of investment. So the different stages have different types of investment associated with them. The early stage, usually the founders come in and own common stock. It may or may not be restricted in the sense that it vests over time. And sometimes your investors will want you to go back and create vesting terms for your common stock. And then the other sort of early stage investments are convertible notes and safes, very common ways for people to raise money at the early stage. And convertible note is effectively debt that converts to equity upon a subsequent financing event. A safe is not debt, but it functions very much in the way a convertible note does, which is that you get the money up front and then that will become equity upon a later financing date. They're commonly accepted forms in the industry for both of these. Y Combinator developed the safe. They've got a new safe out. But here you don't want to reinvent the wheel. I found that in the cannabis industry, perhaps because people are so entrepreneurial and so willing to go against the grain, you see a lot of people coming up with their own sort of structures for how they're going to get investment and thinking, well, we're going to tie it to, how many pounds we're producing or something like that. And my advice there is typically that, you probably don't want to reinvent the wheel when it comes to structuring the forms of investment, just because your investors, you're going to make their heads hurt. And they should be spending their time thinking through your business model and not thinking through, does it actually make sense how they've structured this? And then, it's going to take extra time for everyone involved to sort of bang their heads against the wall and make sense of the investment documents if you're not using sort of standard investment documents. And then preferred equity, which you usually see it, after the seed stage round, though you can see these, early round preferred equity investments, and then finally debt. You're seeing increased debt investment in the cannabis industry, both sort of real estate debt and then sort of traditional term loan lending to cannabis companies. And then, okay, so we're going to talk a little bit about here the timeline of how a financing works, right? And again, this is your typical private placement of equity. Obviously things can vary. You've got the preliminary discussions. Usually this is just business people looking at your deck. NDAs, which is, some people don't like NDAs, but and I do think it's a document that is over negotiated. But basically, when you're revealing information, particularly something that could be tied to a trade secret, you do want the investors to sign an NDA, and then they start looking at the sensitive information. Then you negotiate the term sheet. After the term sheet, you start doing diligence and you negotiate the definitive documents. That's called the pre-signing period. Then you get to signing. And here's where deals diverge a little bit. You have some transactions which are instant, it's sign and close, meaning you sign the definitive documents and you take in the money that day. And it's all done like that. In other deals, you sign the definitive documents and then there's a period of time called the pre-closing period before you actually take in the money at closing. Oftentimes, the reason for that pre-closing period is that you need some kind of regulatory approval for the transaction. And we'll talk about how to sort of think about whether you will need approval or not. But a pre-closing period in a traditional private financing world is somewhat unusual. You see that much more in the M&A world. And then you get to initial closing, subsequent closings, and post-closing. So when I say initial closing and subsequent closings, this is another thing that varies between deals. Most financings, in my experience in the cannabis industry, have multiple closings, meaning that you usually have a minimum amount, say you're trying to raise $3 million, you'll agree that you're not going to take any money in until you raise at least 1 million total. And the reason for that is investors are wary of investing into a company when they know if they're the only people contributing money, it may not be enough to make a difference. But obviously they'll still lose their money. So they want to make sure that there's at least a minimal threshold amount, so they know you're going to get somewhere with the money. And then once that's hit, you can have the initial closing, and then the rest of the money can flow in over time. Those are the subsequent closings. And I'm going to turn it over to Elliot to talk about looking at investors and who the typical investors might be in these financings.
Hey everyone, my name is Elliot. As Charlie said, I'm just brief background. I'm a corporate transactional attorney at Vicente Heederberg's offices here in New York. I've been a corporate transactional attorney for the last 10 years, and so a lot of experience doing these type of deals. Fundraising in all sorts of different industries. So Charlie mentioned, I'll talk about cannabis investors and the related considerations particular to the cannabis industry. We'll go through different types of investors, what these investors are looking for, and then how this information could possibly be presented to them. And then we'll talk a little bit about using kind of investment banks, placement agents, and brokers after that. So first and foremost, you should try and limit who you seek investments from to accredited investors as defined by securities laws. As you all know, the cannabis industry already puts you in a gray area of the law. So seeking only accredited investors, reduces, but doesn't eliminate, at least security laws requirements. And Charlie's going to speak more on those later on. So what is an accredited investor? Broadly speaking, for individuals, they would have to meet one of the qualifications in the Reg D Rule 501 definition of accredited investors. For individuals, these include having 200K in income or 300K jointly with their spouse for the last 2 years and for the foreseeable future, or has a net worth in excess of $1 million, importantly excluding the value of any primary residence. I know we have some social equity license holders and potential applicants listening in. So those requirements can be particularly problematic, and your network may not include individuals that meet those requirements. So in addition to the income and net worth requirements I mentioned for individuals, another way to qualify is if you're a director, executive officer, general partner of the company. So that also qualifies you as an accredited investor. So to the extent you have an individual with cash willing to invest in you, but that individual doesn't otherwise meet the requirements for an accredited investor, which unfortunately happens a lot in the cannabis industry, in particular with the income prong, you can bring them onto your team and qualify them that way as accredited. Now, the obvious consideration there is you don't want to do this too often and have too many cooks in your kitchen. Just something to keep in mind. For entities to be an accredited investor, this generally requires an excess of $5 million in assets, or having all the equity owners qualify as accredited investors individually. So just a brief point on accredited investors. So so many cannabis companies looking for investments, look to traditional early stage investors. So your venture capital and your private equity funds. We'll take a moment here to kind of discuss some of the issues that are unique to cannabis that are different from these, from typical industries. It's important when you're dealing with early stage investors to make sure that they understand these kind of unique considerations early on, since these investors are used to seeing kind of typical economic and controlled deal structures, that unfortunately just don't work when applied to cannabis, or don't work as they expect them to. These kind of considerations, first of all, lead to differences in the timeline. As Charlie mentioned, there may be a need to obtain regulatory approvals post-signing and pre-closing, and Sahara and Charlie will discuss that more in depth later. One related point to note up front there is that certain individual investors in a venture or private equity fund could be subject to disclosure or background checks, and we know from experience that these individual investors typically don't like to disclose any information about themselves. So this is something the venture or private equity fund should know up front, and should understand from their investors what they're willing to provide. Negotiations also typically take longer, since these early stage investors typically expect some form of control, that again may or may not be allowed under the regulations, or may only be allowed in a limited fashion, or perhaps after regulatory approvals. So it'll take time to kind of Charlie, you want to say something?
Sorry, yeah, just to hop in here, I was going to say on the disclosure issue, the background check issue, this is one of the, I think, the key areas in which cannabis financings differ from traditional financings, is that you have a combination of investors who may be shy about the public knowledge of their investment in a cannabis company on one hand, and then regulators who tend to react poorly to being told that you will not reveal certain information about investors. The regulators typically have pretty broad authority to do these background checks. So, I think if you're going to take away, I think one of the key takeaways for today is at the beginning, before you actually talk to your investors, you got to think through what kind of disclosure obligations are my shareholders potentially going to be exposed to, and how do I message that to the investors?
Yeah. And so I was saying this, these things take additional time. You have to work through these issues. You have to make sure investors understand them. And, unfortunately, these take negotiations and, to find the right structure to make sure that everyone's comfortable with, ultimately where we end up and what gets disclosed to the regulators. Second on this list, obviously all your investors should understand that cannabis is still illegal at the federal level. Won't harp on this too much, but, investors are subject to criminal risk. So is the company, the industry. And these risks are real, despite however remote some people, may think they are. And so investors have to be kind of uncomfortable assuming these risks, for themselves and also for their cash. And so you as a company need to be ready to demonstrate to your investors that you're really compliant with state laws and regulations. In general, have a general kind of compliance, atmosphere at your company. This will provide comfort to your investors that you're being as compliant as you're possible, despite the kind of gray area that federal legality overlays on the cannabis industry. Kind of related here, there may be less theoretical risk with ancillary and non-plant touching businesses, but the risks are still there. For example, we as attorneys that service the cannabis industry, we work under those risks every day. But if you are an ancillary or non-plant touching company, typically, technology kind of providers, you may be more likely to get a venture or private equity investor as they're more comfortable, investing in these ancillary and non-plant touching businesses. So outside of your typical venture and private equity early stage investors, a lot of the investments we see into cannabis come from, family members, high net worth individuals. So, after, trying to find your typical early stage investors, these are the type of, investors you should be seeking out, obviously keeping in mind, whether or not they are accredited. We do see public companies investing into other cannabis industries, but you must be mindful that, the regulations either do not address public companies specifically, and thus the regulatory requirements are not clear and may actually be pretty impracticable for a public company, like having to disclose anyone who owns more than 1% of a public company, or the regulations do contemplate public company investments. And so you need to understand those requirements and be able to comply with them and understand the related timing impacts on your funding. Finally, we wanted to note, there's a lot of kind of curiosity out there. We as a cannabis law firm, we get calls every day from people, curious about, the industry, whether they want to get into it or just invest in it. And so, we've just discussed a bunch of different items that, these kind of curious people must understand. Many can get comfortable with kind of the federal legality, but, as Charlie mentioned, a lot seemingly do not want to undergo background checks, publicly disclosed or an investor in the space. So again, these things are important to get out there up front, and you can understand whether or not these kind of curious people are, could actually be considered a legit source of funds, or if they're just not worth your time. So how do you get investors interested in your business, right? So generally, your typical investor is looking for some kind of above market return, on their cash, right? For debt, this means some kind of interest rate that's better than what they get out there in the market. For those not so familiar with the cannabis industry, for a standard loan, not a convertible debt instrument, even if it's secured, we see interest rates, 20+% is, not out of the ordinary. Some of the lawyers on the line might realize that some usury laws get maybe impacted by that. So that's something to also keep in mind, for debt. For equity, above market returns means, some kind of preferential return, whether that be a preferred dividend, a liquidation preference, reference or some kind of other similar financial feature. We won't get into that too much in this presentation. Each one of those probably is its own presentation of itself, but we'll be generating articles on each of those things. So keep a look out on our website for more information there. Second on this list, is strengthen your team, because experienced cannabis investors, know that, one of the most important elements of a successful cannabis business is your management team. So you should be ready to be able to demonstrate to investors, who's on your team, their experience, and that collectively you guys will be able to compete effectively in the markets that you are in or looking to enter. Related, if there's some kind of competitive advantage your company has, whether it be a great management team, great cultivator, you've got a great location on board, you'd want to, or some unique piece of technology that you have access to, you want to be able to highlight that. Now, how do you convey this information to your investors? The timeline Charlie pointed earlier to you, we're still in the kind of preliminary discussion NDA phase. So you can do through just kind of regular conversations, providing an investor deck. Some investors may want to see some kind of confidential information memorandum, CIM. Now, it's not always straightforward whether or not you should be prepared to generate one of these. First, it takes a lot of time and a lot of resources to put together. Second, your company may not be at a stage where there may not be much, if anything, to include in these information memorandums. So why spend the resources and the time? So it's just something to consider if an investor asks you for an information memorandum, or if you are just considering to put one together in the first instance. Now, if you are going to prepare one, and unfortunately, certain investors do require these, whether it be for their fund requirements or the like, you may have to put together one of these CIMs. So a few things to note. You should always include make sure your confidential obligations are covered, and depending on what is disclosed in your information memorandum, you may want to enter into an NDA prior to distribution. You also should include appropriate securities laws disclaimers. Again, we're trying to be as compliant as possible. Other things to keep in mind. Always be truthful. I know there's a general kind of incentive for puffery, but just make sure it's in the realm of realism. Models, you should try to be clear on the assumptions, so because investors are going to ask you anyways, and so they want to know how realistic your assumptions are. And as Charlie mentioned earlier, you have to include a cap table, so that investors kind of know what the ownership stake is. So next, I'll talk a little bit about investment banks, placement agents, and brokers. As we're seeing clients turn to these players more and more because of the. Yep, sure, Charlie.
Yeah, I just want to say a brief thing about these decks, which obviously we see a lot of here. A few points that I didn't, maybe I should have spelled out in the slides here, but one is, for securities law reasons, which we'll discuss later, you most likely want to track everyone that you're sending a deck to. This is to strengthen the argument that you're not making a public offering, and you don't need to rely on 506C securities law exemption, which we'll talk about in a bit if we've got time. And then the second one is, and it's hard for us to give kind of investment advice in terms of what to put in your deck that's going to get someone's interest. But the one thing I would emphasize here that I think we're hearing more and more from the investor side is, people realize at this point just how difficult of an industry cannabis is, and how many sort of unique factors there are at play in the industry in terms of being able to deal with the regulations at the state level and taxes. So I would say, if you've got that industry level expertise, I think we're seeing more and more demands from investors saying, we want to see people that have proven industry expertise. So, and that goes to the strength of your team point. That in particular is something that I think investors will want to see.
All right. Well, thanks, Charlie. So we're talking about now investment bankers, placement agents, and brokers. As I mentioned, we're seeing clients, turning more and more to these types of players. So when is it appropriate to engage them? Obviously, if you're having trouble finding investors. But the first thing to keep in mind is that these banks and agents do have their own internal kind of deal requirements, and typically require the raise to be above a certain amount. And that amount, unfortunately, may be higher than what an early stage cannabis company is looking for. Another thing is also to keep in mind is if you're having trouble finding investors, you should, take a step back and consider the marketability of your offering. Is it the economic terms you've offered? Is it something, about the management team, the business plan, the financial models you included? It's a good time to kind of step back and reconsider that. And just because you hired a bank or a placement agent isn't going to make your deal more attractive to investors. Investors will actually know that you in fact have to pay this person a fee, which is going to limit the amount of capital you get. And also, these banks and agents are going to approach sophisticated investors, probably more sophisticated than the people you've been seeking funds from. So, you need to keep these things in mind. And next, and just because an agent's willing to enter into a fee agreement with you, it doesn't mean they think that your offering is a good one either. Their business, they're looking to collect fees, and so it's something to keep in mind. So if you do engage an agent or broker, one important factor to get out of the way early is do they have experience in cannabis? Ask about their prior deals, and their role in them. And it's better obviously if you can be referred to an agent or broker by someone who's previously used them successfully to raise money, for a cannabis company. It shows that agent or broker does have a reliable network of investors that are willing to put up funds for a cannabis industry. So now we'll talk a little bit about the fee agreements and kind of the types of fees you'll see with brokers and agents. The types of fees, typically include, possibly warrant coverage. So this is an option to buy shares at a specified price. These agents will want upfront retainers, along with potentially monthly, retainer fees to continue their engagement. On these kind of retainer monthly fees, you should understand if these fees are counted as part of the transaction success fee. So, they'll be reduced from that ultimately. And also what services, if any, the bank or agent is going to provide for those fees. Are they going to help you with putting together the CIM? Are they going to help you with investor presentations, and the like? And so the most important fee for these brokers and agents are the other transaction or success fees, which is the percentage of the raise amount. Now these percentages are significant. You see anywhere from 7 or 10%, and so something you need to consider. With your financing, and because it's going to add a material cost to your raise. Another point on these success fees is that the fee agreements often include a tail, and so that means if the broker agent introduces you to somebody, you terminate the fee arrangement, and then ultimately you gain funds from that investor. Your ex-agent, maybe due a fee under the tail. So it's something to keep in mind when you enter these agreements. Is there a tail, and how long is it? And finally, again, we're harping on compliance. Make sure your agent, is registered as a broker dealer. You can check this on the FINRA website. It's easily available. We're seeing, far too often now, individuals, our clients coming forward with individuals claiming to be these great agents or brokers, or these people with great cannabis networks, but without the proper registration. And so again, you're already operating in a gray area as a cannabis company, and so you want to be as compliant as you can, and that includes making sure any broker dealer you engage is registered as such. I'll now send it back over to Charlie, who will discuss term sheets.
Hey guys, so talking about term sheets here, I think, we're third, I want to leave some time for questions at the end. So we're going to just sort of speed through the term sheet stage and get into the regulatory nuances here, because I think that's what, really separates a cannabis financing from a non-cannabis financing. So, here's some notes. Obviously, we'll be sending this around the group. So, some important things to think through here on the term sheet stage, which we may come back to if we have time. But let's get into the meat here. So Sahar and I are going to talk about this here. So this is cannabis regulatory considerations. So here are sort of 5 buckets of issues you got to think about, and I'll turn over halfway through to Sahar. So first one is state level approvals. Some transactions will require state level approvals. Some will not. You got to think through the state level. Then you've got the local level approvals. And this is really a state by state issue. By that, I mean, some states like California, you've got a lot of issues at the local level. I'm sorry, are people getting feedback from me? Okay, maybe not. Yeah, so local level approvals. Some states, the localities are very important from a corporate transaction standpoint, and some they are not. And then the third one is suitability representation. So basically every state's going to have something along these lines, which is going to say, anyone who owns equity in a cannabis business needs to meet certain qualifications. And those qualifications may differ based on how much equity they own in the company, if they're sort of above a materiality threshold. And even if the suitability requirements don't differ between sort of, call it, material owners and non-material owners, they will in practice, because in a lot of states, once you get above that threshold, the regulators are potentially require pre-approval, and certainly will have more in depth of a background check. So if there are suitability issues, those are far more likely to come to the fore. And so you're going to want to make sure, and this also can imply, it's not just what you're thinking about, which is, that you don't have a criminal record, et cetera. It can also come into play in terms of ownership. So if you have an ownership and a testing license, that may preclude you from also investing in another type of license. So these are the kind of reps you're going to want to make sure you get from your investors to make sure you don't accidentally violate state cannabis regulations. In addition to the testing piece, the other big one is a licensing cap. So, a lot of states will have limits on how many licenses you can own or control. And so it's important to realize that depending on the size of the investment, that can also be triggered. So going back to the original point I was making, which is that you want to understand all these issues up front. You do not want your investor to ask you this question halfway through the financing, and then you're scrambling to discover, hey, what if they have a testing license ownership piece? Is that going to create an issue? You're going to want to do this analysis up front, and you need to do this analysis in all the states in which you own a license, and also any state in which you're thinking about getting a license in the near future. So if you're doing a financing, you've got applications in for a certain type of license in a state, take those into account, because once you get awarded those licenses, if these people are stepping into your cap table, can be an issue. Sahar, you want to talk about pre-approval versus disclosure?
Yeah, so depending on the jurisdiction you're in, state by state or locality by locality, investors will need to be either pre-approved by the regulators there, which means that prior to closing, you'll need to disclose them to the applicable regulators, have them potentially undergo background checks, or just disclose them or have them approved after closing takes place. And it's really important to be aware of the timeline and the requirements for each of the applicable jurisdictions, because while some may need pre-approval, others will need post-closing disclosures, and you just want to make sure that you are providing information to the regulators in the timetable that they require and providing full information to them, because that just tends to make everything easier. As far as the materiality threshold goes, states will require those who own a certain percentage in a license to be disclosed and sometimes undergo background checks. So it's really important to understand what those thresholds are for each of the applicable jurisdictions, so you can let investors know of them. You can let investors know that depending on, for example, how much they invest, they may be expected to undergo background checks. And these vary state to state. And with respect to publicly traded companies, a lot of states have a cap on the threshold for the shareholders in a publicly traded entity tends to be around 5%. That we don't really see that in private companies.
Thanks. So yeah, I know it can be a little frustrating. We're talking about sort of these big theoretical issues, but the reason why it's so hard to give specific concrete advice here is because you have to know not just the states in which the licenses are involved, but you have to think about what localities, particularly in a place like California. So, we're going to give you a little sort of concrete piece here. So, Sahar, you want to talk about raising money into a California licensed business?
Yeah, so California has a dual licensing structure where a licensee needs to hold a license from both the locality as well as the state. And while some local rules tend to track the state's rules, especially as far as disclosure requirements, for example, others have their own. So on the state side, you usually will disclose new owners after closing, whereas certain localities will require pre-approval of owners. And California on the state side also has two different levels of ownership, one of which is an actual owner, which requires background checks, and then there's a financial interest holder, which is a lighter level of disclosure. So you'll want to be aware of where your investors will fit within that and prepare them for that level of disclosure.
All right, so I'll talk about Colorado. So raising money into Colorado, pretty high level. If you're not taking on any shareholders that are at a 10% or above threshold, you most likely will not need regulatory approval for the transaction. Obviously, everyone's got to meet the suitability requirement. You also most likely will not need to disclose the names of all your shareholders to the regulators. Unless something comes up, the regulators have full authority to ask for that, but they typically only, under the current system, only want to know about what's called a controlling beneficial owner, or CBO, which is the 10% level. Now, obviously, like anything in cannabis, there's a lot of nuance here. One is, if you've got control over the company, you got to be disclosed no matter how much stock you own. So you can't come up with a structure where you own 3% of the company, but you have veto rights over all the decisions of the company. That would be control and require approval. The second is, in Denver itself, it's usually pretty easy. The city follows the state from changes of ownership perspective. But when you're dealing with a small, if you're investing into an operation that's sort of in a ski town, let's say, some of these small towns have kind of unusual local issues. So you just want to double check that before you pull the trigger. And then finally, anyone who's going to get added to the board. So if an investor wants a board seat, that's fine. But they will need to go through the background check process. So please make sure they're aware of that. And then Elliot on Mass.
Hey, sorry, I was just responding to some of the questions in the chat. So in Massachusetts, generally, if you have more than 10% or more of the ownership of the company, there's a required approval there. In addition, any directors or executive officers are also subject to approval requirements. Now, importantly, for people that like to use convertible debt instruments, which seed stage investors try to do, right now up in Massachusetts, there were proposed rules, and one of the proposed rules actually covered convertible instruments and would require pre-approval for anyone who could possibly own more than 10% of the company upon conversion of the debt instrument. Typically, you would only need the approval to be made, if and when the debt's converted, but this proposed rule up in Massachusetts would actually require approval for the debt instrument itself, before you actually could even take on the funds. Obviously, we don't think this is a good rule, and when we're providing comments to that and talking with the regulators. So, hopefully this last bullet point under Massachusetts is not applicable, but it's something to keep in mind.
Thanks. So I just want to hit some key points here on sort of unique cases before we turn it over to questions. So if you got any questions, please write it in. We'll address it here in a few minutes. So the first one is non-licensed holding companies. So in a lot of cases, Washington State, for example, there's a residency requirement. So you can't have anyone from out of state on the license as an owner. So obviously that makes raising money difficult. You used to see that in Colorado as well. So in these cases, what you typically see is sort of almost a parallel structure. Money's raised into the real estate holding company or the IP holding company or a company that provides consulting services to the licensed business. And there may also be loans. Now, this, as you might imagine, is something that cannabis regulators take a keen interest in because it could be viewed as an end run around the rules. So you need to be careful to vet exactly how the mechanics work here. But that's a very common sort of structure seen in the space. Another one, social equity licenses. Social equity licenses, you got to be really careful here. If you need to maintain the social equity license, it may be in some cases that losing the social equity status is not the end of the world, but in a lot of cases, it will be a significant problem. So you need to think about whether the financing will throw off the demographic requirements for your management, whether the ownership thresholds will be impacted. In a lot of cases, the social equity applicants need to own a certain percentage of the company, or if control rules, right? If you're giving sort of small equity holders veto rights, if that could put you offside. So that's a case. It's another sort of common issue. And then technology and ancillary companies don't have to deal with a lot of this stuff, but you do have to, the smart investors, and like I said, things are getting tougher and investors are getting smarter, are going to ask you questions around, well, what's your relationship like with these licensed businesses? Can we see the agreements? Have these agreements been vetted by the regulators? So you want to understand the control and economic relationship with the licensed businesses, and to make sure that that is acceptable under all the regimes in which they do business. So that's sort of a response to the, I would say, pre-vet that answer to investors prior to getting the financing underway.
Hey, Charlie, one other point on the technology and ancillary companies. Just because you're non-plant touching doesn't mean the regulations are not applicable to you. Outside of the control aspects you probably mentioned, certain states are starting to implement regulations specifically for technology providers that are non-plant touching things. So now you don't necessarily need to get a license from the state, but there are regulations you would be subject to. In Massachusetts, they have a term called, I think, a technology platform provider. And so if you run, say, like an online marketplace that caters to cannabis companies, you're subject to certain regulations up in Massachusetts. And I think California also has a kind of similar type of regulations. So, again, not necessarily applicable to fundraising, but just, for the people that are thinking about non-plant touching businesses, keep that in mind, please.
Right. So yeah, that's a great point. Thanks, Elliot. And then two other kind of buckets of finance that we deal with commonly and issues to think about here. Funds. Some unique ownership structures may not be contemplated by a state's regulatory regime, and that can present issues down the line. So you're going to want to pre-vet it. Things like family offices, trusts. If there's a trust where there's a beneficiary that's under 21, that can pose an issue. So you want to think through these kind of issues up front. Some states have specific disclosure requirements for, say, a venture capital fund. Some states don't. So this is something else you want to think through in advance. So you don't end up in a case where the regulators are demanding information and your investors are saying, we're not going to provide you a list of our LPs. I know I sort of keep harping on it, but that's a very common issue to run into in these cases. And I would say in 99% of the cases where a background check is an issue, it's not that you've got an investor that, has committed some crime that would disqualify them. It's that the investor says, I myself have investors and I've promised them I'm not going to disclose their name to a regulator. And that, again, it doesn't mean you can't do the deal, but these are issues you should think about up front rather than, post-closing when you're getting the regulatory request. And then finally, these are sort of the 6 buckets of issues we see with debt transactions, which are disclosure versus pre-approval for the loan itself, the background checks for the lenders, very similar to equity deals, and then debt-specific stuff like collateral, whether you can take a secured interest in the licenses, in the marijuana or the marijuana product, covenants and control, to what extent are traditional affirmative and negative covenants in a debt transaction considered control, which again would trigger approval requirements in many states. Pledge agreements, can you pledge the equity of a licensed company? And then, of course, the big one, insolvency. What happens in an insolvency scenario? Can you step into the shoes of the borrower? Can you transfer the licenses? Everyone knows you can't go into federal bankruptcy, but how do state receivership issues play out? Obviously, that's probably a totally separate presentation because the level of nuance. And then, you see these questions, the answers sort of differ from state to state. So you really need to know the states involved to kind of approach it. So with that said, I'll turn it over to questions and see what we got here.
Yeah, so Charlie, there's some questions in the chat. I think the first one that is an answer is from Sarah about DEA registrations for Schedule 1. So there's the distinction between federal and state laws, and so the states aren't going to require DE registration for cannabis businesses. The closest analog we have to this is the way the federal government's regulating hemp these days, and the USDA interim rule and the DEA just also released an interim rule. And the first iteration of the interim final from the USDA actually required laboratories to be DEA registered because of the possibility that if they tested hot hemp, they would actually be in possession of a Schedule I controlled substance. But anything about DEA registration would have to come from the federal government. I see Steve with a social equity license. So certain states, when in their cannabis programs, whether medical or adult use, they define a social equity kind of applicant, generally based on whether or not the individual owners were previously incarcerated for cannabis crimes, or had immediate family members that were incarcerated for cannabis crimes, come from communities that the state identifies as being disproportionately impacted by the war on drugs, or perhaps fined by some kind of poverty threshold. So the licensing regimes typically include certain benefits for social equity licenses, such as maybe, bonus points on the application, preferential, application review, priority in certain licenses or locations. But as Charlie mentioned, tied to the social equity, license, there are certain requirements, such as, having majority of your owners be qualified as social equity applicants, however the regulations define it, and so then those ownership requirements and control requirements, are important too when raising funds, because you have to keep those in mind when negotiating with investors. I see Lori. Sorry, go ahead, Charlie.
I was going to say, yeah, I'll look at the same question about value of cannabis companies. So it's a very difficult question to answer because there's not really a national marketplace for cannabis companies. It's so state specific. And particularly when you're seeing people ascribe value to the licenses they own, you get into the question of, well, how much is the license worth? So it's not necessarily tied to revenue or EBITDA. It's a question, it's a political question, are they going to issue additional licenses in this location? Or are these people going to be, going to have sort of an oligopoly for the foreseeable future? I mean, I can tell you in Colorado, people will say when they're talking about a licensed cannabis business, you're usually looking at a multiple of revenue, something like 0.7 to 1.2x revenue would be, and you have seen sales sort of some of the big name sales of the green solution. You can Google it. I think they were 2x revenue last 12 months. That's a public deal. But that's kind of the metric I see. I haven't been able to get from people in sort of less developed states clear metrics on how much things are worth, because you get into things like, well, we've got, this locality in California isn't issuing any more licenses and we've got the good locations.
Hey, just to add on to that, Lori, I guess like the traditional kind of historical example here, their similarity was like the website valuations. Back in the a couple of years ago in the cannabis industry, everyone was talking about number of licenses, licensable cultivation square footage. It was kind of similar to, I remember back in the .com bubble, people talking about page visits, unique clicks, and things like that, and people were valuing companies based off of these non-kind of financial metrics. But that kind of all has changed recently within cannabis over the last kind of year and a half. As we've seen the kind of stock market prices adjust, and Charlie mentioned, I believe cannabis companies today are being valued kind of on more traditional financial metrics. Maybe the multiples and the ratios aren't kind of similar to industries today because of the cannabis nature of it, but that's kind of how investors are looking at company valuations.
Yeah, and it just obviously caveat, we're talking about private financing, that the public stock markets are a different beast.
Yeah.
So we got a question here about defining plant touching. So, I mean, I think you get different answers from different people. My definition of what is a quote plant touching business is someone who has a license, a state and a local license. So you may not, so in that sense, a testing company would be a plant touching company because they do have a license, though I could see an argument that you're not really trafficking the substance. And then you're not plant touching in that sense. But that's typically the distinction from a legal perspective is if you got a license, then you got to worry about all this ownership change stuff for a license. If you don't have a license, even if you're sort of aiding and abetting, it does simplify some of the factors. I don't know if you guys have a different view on what's quote plant touching.
Yeah, that's kind of generally how I view it as well. Obviously, if you touch plant at some point in your business, you're plant touching. Examples of non-plant touching businesses are people that make maybe the vape hardware that you see, but they don't actually ultimately fill up the cartridges. People who make the cartridges, smoking devices, and kind of items like that, are considered non-plant touching. And then you do have, as you mentioned, certain service providers like technology platforms that will provide, say, like inventory tracking software to companies. The software maker itself doesn't actually ever touch plant. They just, develop the software around tracking all that. So those would be other examples of kind of non-plant touching businesses.
And I just want to jump in and say, even if your company isn't a plant touching business, it doesn't hold a license, it may still be subject to regulatory disclosure based on the relationship that it has to a plant touching company. For example, if there's revenue sharing and whatnot. So even if you don't fall within the bucket of license holding plant touching business, it doesn't mean that there's absolutely no regulatory disclosures on your part, depending on what jurisdiction you're in.
Yeah, that's a good lead in. So do you want to talk a little bit about disclosures for brands in California?
Yeah, so in California, generally, for example, with an IP company that licenses its intellectual property to a plant touching company, for the plant touching company to create products using the IP, it's a little bit of a gray area where disclosure is. The California rules specify that where a company receives a portion of the revenue of a licensee, that company has to be disclosed as a financial interest holder or an owner, depending on the amount of revenue they receive. And additionally, if the IP company has control over the business, so if, for example, they're telling the business how to run all of their extraction or how to run all of their cultivation, that level of control would arguably make the IP company an owner and make them subject to a higher threshold of disclosure, which would require background checks. Generally in California, there are a good number of entities that believe that if you have, for example, a flat fee model with an IP company, so you're not going to be receiving a portion of the revenues, so you're not subject to disclosure by the regulators. Either way you take it, it's important to remember that regulators have a pretty broad ability to ask for disclosures. So even if you go with, say, the flat fee model and you don't disclose yourself as a financial interest holder or an owner on a licensee that you're working with, the regulators can always come back and ask for you to be disclosed in whatever capacity they see fit.
Thanks, Sahar. So I guess, just in the last 60 seconds we have left, I got a question about whether we've seen financing for energy efficiency upgrades to cultivation facilities in Colorado. And yeah, I've seen people, I've talked to investors who are interested in basically real estate expansion lending. We've definitely seen that. I mean, I haven't seen a lot of deals. I know people are interested in potentially exploring it, if it makes sense for them. And I guess lastly, I'll say if everyone goes to the offers section, you can see we've got a book on cannabis law that's coming out end of December 30th, 2020. All of our profits are going to be donated to charity, to the Last Prisoner Project. And, obviously in a book format, we're able to get into a little bit more detail in terms of things like the federal law, how does state excise tax work, how does this impact the IP, sort of the type of stuff that we see on a day-to-day basis here. We try to kind of lay it out for everyone. And we'll be back on September 10th with a webinar on M&A, which, as you might imagine, can get pretty complicated in the cannabis space. So hopefully have a chance to speak with all of you soon. Thank you very much for your time.
All right, thanks everyone. If we didn't get to your questions in the chat, we'll
you can always email us.
Yeah, back to the email.